This video, I want to take a look at something that's coming up in 2018, in May 2018, which is going to have serious implications for organizations and employers in particular. It's to do with data protection and new data protection law that's basically coming into Ireland. It's coming into all of Europe, but it's having direct effect in Ireland on, I think it's the 25th of May 2018. So this is what this video is going to be about. If you are an employer or are a data controller in an organization, you should, I think, find it helpful. If you're a subject or a data subject, for example, an employee in an organization, you may find it helpful as well, because the new legislation, the new law coming in on foot of this general data protection regulation from Europe is going to give data subjects enhanced rights. So, as I say, it has direct effect in Ireland from 25th of May 2018. The effect will be to replace the existing data protection framework in Ireland. So currently we've got two, I think it's data protection acts on our statute books, the 1998 Act and the 2003 Amendment Act. This is going to lead to a new act being brought in, which is currently, I believe, in published bill with the government or whatever. Hasn't come in yet, but the broad thrust of what's in this GDPR regulation will have to be given effect in any legislation that's passed in Ireland. Essentially, it involves new obligations for data controllers and new rights for data subjects. There are three principles. One, security of data. Two, accountability. Data controllers will need to be much more accountable for the gathering and processing of data. And three, transparency. Extra enhanced rights for data subjects to obtain the data that's held on them, and to have data amended, and even the right to be forgotten, to have data extinguished or deleted. So what will change for you? Well, are you a data controller? If you are a data controller, then you're going to be looking at big changes. There's a number of changes, and I'm going to go through them here, but you know, while the video might seem intimidating to you and there's a lot of information in it, this is really an area that could cause you serious difficulty if you are a data controller. For example, if you're an employer. Financial penalties. There are going to be severe financial penalties for breaches of the General Data Protection Regulation and the broader data protection law. Penalties can reach 4% of an organization's worldwide turnover, or 20 million euros for breaches of the data protection law. So clearly that's very, very significant. The right of an individual then, whose rights have been breached with respect to data legislation and data protection, have been greatly increased and enhanced. Currently, an individual, if there's a breach of your data protection rights, as for example an employee, all you can really do is make a complaint to the Data Protection Commissioner. The Data Protection Commissioner can then investigate and issue a sort of a recommendation or warning against the data controller. However, you cannot gain financially unless you can show financial loss. The new scenario is going to allow you to recover for non-material damage. So any damage that's caused to you, currently you need to show loss. You need to show either physical damage or psychological or psychiatric damage or financial damage. Then you may be able to recover. But broadly, it's a wrap over the knuckles for the data controller. In the new scenario, the new situation from next May, you can, as a data subject, as an employee, for example, recover for non-material damage. So that would, for example, include stress caused to you as a result of the breach of your rights. Greater transparency. The GDPR now obliges the data controller to address a list of questions about the gathering of data. Questions would include the legal basis for processing the data, how long it will be retained, and detailed information for the data subject about their data protection rights must be given to the data subject. Questions would also include what's the purpose of gathering the data. And essentially, if you're a data controller, if you're gathering data and it's not gathered for the purpose, the stated purpose of the data processing, well, then really shouldn't be gathered. An organization must be able to show compliance with the principles of the GDPR as well. So that's a burden of proof that shifts to the data controller, obliging the data controller to show compliance with the data protection law, the new data protection law. There's a greater obligation now in terms of record keeping. There's no requirement to register with the Data Protection Commissioner, and if you have less than 250 employees, there's no record keeping burden. However, you do need, if you're a small organisation, appropriate data protection policies. For example, a general data protection policy, a website cookie and privacy statement policy, a policy for the use of CTV, a policy for the use of email, internet, interaction with social media sites, and so on and so forth, from the workplace. So greater record keeping obligation. Consent then is a huge issue in the new GDPR regime. Is it enough for a legal basis for processing? In other words, if you're a data controller and your data subject has consented, is that enough for a lawful basis for processing? Probably not. It's vital that the consent that is given, though, is given freely, and it can be freely withdrawn at any time, and it should be as easy to withdraw it as it is to give it. As I say, the consent needs to be freely given, specific, informed, and unambiguous. The organisation must be able to prove that they obtained the consent. It's unlikely that the consent will be regarded as freely given if there's a huge inequality or imbalance between the parties, for example, an employer-employee situation. So if you consider many companies, many employers issue contracts of employment, and in it there'll be a provision in relation to data protection, and that will state basically that the data subject is consenting to the use by the employer of data protection or personal data. That type of consent that's bundled in with a contract of employment may not necessarily be certainly not advisable, because the consent is not that freely given or unambiguous or specific. It's bundled in with something else, and there is an imbalance between an employer's powers and employees' powers. Let's face it, if an employee is getting a new job, he or she is likely to sign anything, so if that includes a data protection thing, the employer needs to be careful that the consent is a genuine consent. So it's unlikely that the mere giving of consent gives an organisation a legal basis, a lawful basis for collection of data. A more reasonable legal basis for collection rather than consent would be, for example, the performance of the employment contract or compliance with legal obligations, for example, tax obligations or record keeping for employment law purposes. These are legal bases for gathering data. Or another one could be the legitimate interest of the employer, but it needs to be a legitimate interest. The consent must not be bundled in with other terms and conditions of a contract between the parties. For example, a contract of employment. It must be separated in a separate consent declaration, and the burden of proof, of proving that a valid consent was obtained, is on the employer. The GDPR makes provision for a data protection officer, a DPO. Some organisations will need to designate a person as a data protection officer. These organisations would include public bodies, large organisations. If you are a data controller in an organisation, you need to consider whether you need a data protection office in your organisation. Other organisations that will need a DPO will be public authorities and organisations who systematically and regularly monitor data subjects on a large scale. Also, organisations who process sensitive personal data on a large scale or data in relation to criminal offences, these organisations will need a dedicated data protection officer. This officer may come from the organisation itself, or you can appoint an external person to the role, and it is envisaged that organisations may well be set up to provide this type of service, this data protection officer service, to organisations, to a number of organisations. The data protection officer must inform and advise the organisation of its obligations under GDPR. It must provide advice, or he or she must provide advice and act as a point of contact with the supervisory authority, that's the Data Protection Commissioner, and monitor the organisation's compliance with the law. And reporting data breaches, that you must ensure you have sound procedures in place to detect, report and investigate any data protection breach. This new law will introduce mandatory data breach reporting obligations to the Data Protection Commissioner, and failure to report a breach will result in a fine in addition to the fine for the breach, if a fine is imposed. and breaches will typically have to be reported within 72 hours. So there's no beating around the bush or sitting on your hands in relation to this. However, if there's no risk to the employee's data rights, there's no obligation to report the breach to the Data Protection Commissioner. Data subjects then are going to have enhanced rights to have, for example, inaccurate data rectified, to have personal data erased without delay. This is a new right, a right to be forgotten. Data subject will also have the right to restrict the processing of their personal data. They'll also have the opportunity to object to its processing altogether, although this should be on compelling, legitimate grounds. They also have a right to data portability. This is the right to obtain and use their own data for their own purposes across different services. This could occur, for example, if you're moving jobs, or indeed moving banks or something of that nature, maybe moving medical advisors and so on. And also the right not to be evaluated on the basis of automated processing of data. Data subjects, these data subject rights, however, are not absolute. For personal data to be erased, it must no longer be required for the purpose for which it was acquired. So if an employer, for example, has data and needs to retain it to be compliant with the law in relation to record keeping and so on and so forth, the data subject then does not have the right to have that data erased. So obviously these new rights create new obligations and headaches, quite frankly, for data controllers, but that's the way it's going to be. The GDPR also introduces the concept of a data protection impact assessment. This basically involves an assessment of carrying out a systematic consideration of how a particular initiative that might be carried out will impact on the privacy of individuals. The assessment may involve discussions with groups and stakeholders, and the whole thrust of this DPIA is to identify potential problems with an initiative involving the gathering of personal data and look at ways to mitigate those problems. So if you need a data protection impact assessment, who carries it out, who needs to be involved, will it be run locally or centrally? An example is where an employer is going to start monitoring employees' use of the internet. Also where a hospital may start processing its patient health data in a particular way. So a data protection impact assessment should contain a description and purpose of the processing, an assessment of the necessity for the processing operation, an assessment of the risks to the rights of the data subjects, and what steps are going to be taken to reduce or mitigate these risks. Data portability is a new right for a data subject. It's a new concept that allows the data subject to transmit its personal data to another data controller. It can be done by the data subject receiving the data and giving it to the new data controller, or having the first one transfer it to the new data controller. The right is not an absolute one and only applies to automated data which was effectively and knowingly provided by the employee to the employer, and the personal data must have been processed by the employer with the employee's consent. It would not apply, therefore, to data which was held by the employer and processed based on the legal ground of legitimate interest or for a specific legal obligation connected with the employment relationship, for example, payment of statutory obligations such as tax or PRSI. Data subject access requests, then, they must be complied with within a shorter time frame of 1 month. However, employers can extend it to 2 months if there's complexity involved in fulfilling the request. If a request is manifestly unfounded or excessive, the employer can refuse the request or charge a fee. Demonstrating compliance, this is the burden of proof. The data controller will need to be able to demonstrate how they comply with the data protection principles. So the burden of proof is on the data controller. This would mean that employers, for example, would need to be able to show that consent was given and that there are compelling legitimate grounds for processing the data where the data subject objects. In conclusion, GDPR is a far-reaching piece of secondary legislation emanating from an EU directive. It should be of particular concern to data controllers and employers. Data controllers will need to look very, very carefully at their existing data protection policies. They'll need to look at how they gather data, why they gather data. They'll need to look at the procedures for responding to data protection requests in the future, and when they need to carry out data protection assessments. They also need to look at whether they need to appoint a data protection controller or a data protection officer rather. They need to review their existing data privacy policies and notices. If you need advice or training in this area, my name is Gorry. I'm a solicitor in Enfield. You can give me a call or you can send me an email. Email is probably the best way to reach me. Thanks for watching. I hope you find this video useful, and if you do, you might give it a thumbs up down below if you're watching it on YouTube or Facebook or wherever. Thank you.